The IRS announced on August 29th that due to Supreme Court rulings, the IRS will now recognize for federal tax purposes all legal same-sex marriages. What does this mean for your payroll and HR departments and for your employees' taxes, withholdings, and benefits? Wait, you say. My state does not recognize same-sex marriage. That may be true, but for IRS purposes, you are required to recognize them whether they are legal in your state or not. If the couple got married where it is legal to do so, then for federal tax purposes, they're married, regardless of where they live. Your company needs to be ready no matter where you are located. Now, this ruling applies only to marriages, not to include other unions such as registered domestic partnerships, civil unions, or other formal unions that may be recognized by some state statutes. There are going to be many changes. The first for the payroll department is couples changing their exemption status. Same-sex couples will be filing joint tax returns starting on or after September 16, 2013. In many cases, this means their taxes are going to go up. The marriage penalty will apply to all married couples now. Same-sex married couples must file either joint returns or married filing separate returns. Couples that have been legally married may file amended returns for the last few years. Normally that would be 2010 through 2012 if it lowers their taxes. However, if filing an amended return would increase their taxes, they are not required to file an amended return. However, if they file an amended return, both spouses are then taking on joint and severable responsibility for each other's taxes, unless they can get relief under the Innocent Spouse Code sections. This means if your spouse has been fudging on their taxes, you don't want to file an amended return with them. See your CPA first. If your company offers benefits to married opposite-sex couples, will you be required to offer the same benefits to married same-sex couples? Some examples: flexible spending and health savings accounts. A same-sex couple should be able to take advantage of the plans just as married opposite-sex couples can. The IRS is expected to issue more guidelines. Qualified retirement plans. A qualified retirement plan must treat same-sex and opposite-sex married couples the same way. The deduction limits and contribution limits to IRAs and Roths are now those for married couples, not for two individuals. How about insurance? Those individuals who purchased insurance on an after-tax basis for their same-sex partner may now be able to treat those amounts as pre-tax and excludable from taxable 1040 income. Also in insurance, if your company picks up some or all of the premium for spouses or families, and Sally comes in on Monday and says, "Here's the information on my new spouse, Sarah," what do? Let's take this situation a step further. Unlikely today, but not totally out of the ballpark. Ted comes in and says, "In addition to my wife, Mary, I have an additional spouse, Steve. Please add him to my policy as a spouse and pay for it." What then? Basically, anything under a cafeteria plan is going to have to be looked at the same way for a same and opposite sex couple. There are some interesting complications that do come to mind. Can both partners of a same-sex marriage get pregnancy leave, even at the same time, if you offer pregnancy leave under FMLA? FMLA has leave for adoption. So in a same-sex marriage, who gets leave in a state that does not recognize the marriage but only an individual for adoption purposes? Can you ask for proof of marriage? Have you ever asked an opposite-sex couple for proof of marriage? If not, can you ask a same-sex couple for proof? What if your company prohibits supervisors from dating subordinates, and your state does not recognize a same-sex marriage? You fire one married same-sex partner, and you get a federal lawsuit, not a state lawsuit, because under federal law they were married, under your state law they were simply cohabitating. HR is going to have fits for years. What about common law marriages formed in a state where same-sex marriage is legal? Are they then legal everywhere? There'll be some major disruptions with the federal government recognizing these marriages and some states not. A number of states follow federal law for state income tax purposes. You supply a copy of your federal tax return, make any reconciliations, and pay a percentage of your 1040 tax or income. If the state does not recognize the marriage, how can they recognize a joint federal return from a same-sex married couple? The taxable income shown on the W-2s may not be the same for state purposes as for federal purposes. Our payroll department's going to have to calculate a whole different income for state purposes and prepare different state-only W-2s? Stand by for complexity with a major chance of misunderstanding and confusion. Consult with your payroll tax professional before changing anything. Our next blog is planned to be a primer on PEOs. Please sign up on our blog page at www.payrollonabudget.com/blog to make sure you don't miss any of our future blogs. Thank you.